Thank you, Shirley. Thank you very much. And Shirley's wearing the best pair of boots I've seen for ages. I'm afraid my journey has been nowhere near as exciting as Deborah's. When I left school, perhaps like quite a few of you, I didn't have the faintest idea of what I wanted to do. I knew that I wanted to sort of go on and do something at university. And so the mob that I hung around with, a group of 3 or 4 of us, we were pretty well inseparable, were all going off to do law and something. Well, I was interested in history and stuff like that, so I did an arts degree and a law degree, and that was at the time of the Vietnam War, and national service was in place, and my marble came out of the barrel, and so I was called up for national service. I was able to defer until I'd finished my degrees, but as soon as I'd finished them, and even before I'd actually graduated, I had to wander off and do my national service, which I did in the Royal Australian Air Force. While I was in the Air Force, I was approached one day. I'd just finished my officers' training course, and I was approached by one of the education officers, and he said to me, "Ah, David, I see you've got a degree in English." I said, "Yes," somewhat suspiciously. And he said, "Are you interested in doing a bit of teaching?" And I thought, this is odd. Teaching what to whom? And he said, "Well, we've just lost one of our education officers. We need someone to run some English programs for the RAF apprentices." And so I did that for 1 day a week for a couple of years. And I enjoyed it so much that when I finished that 2-year stint, I went back to university and I did a dip ed, and instead of becoming a lawyer, I became an English teacher. And I taught English for quite a while. My particular fields were English grammar and ancient and Middle English, but also English literature, and I was sort of pretty steeped in literature. And so I really enjoyed doing that for a while. And then all of a sudden, a subject started to emerge, and that subject was eventually legal studies. And I thought, well, seeing I've got a law degree, I might as well put it to some use. I did 4 years of slaving over musty old law books. There was no computers in those days. And I became a legal studies teacher. And for about 37 or 38 years, that's exactly what I've been. And I've enjoyed it enormously. I loved teaching the subject. And as was explained, as Shirley explained a few moments ago, I took up a role at Victoria University in the Sir Zelman Cowen Centre, which involves me in programs like this and other school outreach programs. And about 15 years ago, I became a teacher in residence at the Victoria Law Foundation, and that's, I suppose, the reason why I'm here today. But enough about me. Last year, I'm going to talk about you. Last year, you completed Units 1 and 2 under the old study design. In Unit 1, you would have looked at the criminal justice system, and in Unit 2, you'd have looked at the civil justice system. What other areas did you have a look at in Unit 2? There's a number of sort of options that you could have studied in Unit 2. What were some of those options that you looked at last year in Unit 2? We covered the sort of conventional stuff on torts and contract and that sort of thing. What else did you look at in Unit 2 last year? Family law. How many of you looked at family law? Quite a few. What else? Workplace law. Good. Yep. Okay. Any others? Any others we haven't mentioned? Sorry? The law of privacy. Okay. I can't hear from back there, but never mind. I'm sure it was absolutely right. Now that all gave you a very sound base from which to go on to Unit 3 under the new study design. By the end of this semester, you'll also have had a look at the criminal justice system and the civil justice system. Now, students who weren't very smart may well have said, "Hey, I've done all this before," and sit back and have a very relaxed semester 1 in 2018. On the other hand, smart students, and that includes all of you, or you wouldn't be here today, would have realised that what they were going to do this semester, and indeed in the rest of Unit 4, or in the rest of Unit 3 and then in Unit 4, required a much higher level of thinking. Similar topics, yes, but they're being covered, as you would have noticed, at a rather higher level and requiring much more analytical approaches. Now, in the material that you've been given in your show bag, you'll find that you have a copy of the study design for Units 3 and 4. If you can just dig that out. I've sort of tried to avoid being proceeded against for breach of copyright by describing it as the knowledge audit, but it is in fact the study design. It's in the middle pages, pages 7, 8, and 9 of the handout that you've got in front of you. And the reason that I've produced this as a knowledge audit is so that you can, as you work progressively through Units 3 and 4, you can check off what you reckon your study notes cover appropriately. So, for example, if we look at the second one, distinction between summary and indictable offences. Now, doubtless you can all make that distinction, so you could put a tick in the yes column, but if by some chance you were away when that work was done, you put a cross in the no column, I guess, and you write yourself a little note so that you can, in fact, get your notes on that topic sorted out. And I'll come back to that first point about principles of justice in a moment. But that knowledge audit is something that you can use as a vehicle for your revision as the semesters continue, as semester 3 continues, and as you move into semester 4, which won't be very far away. The document is there to assist you, and I think you'll find that will be quite useful when it comes to ensuring that you do have study notes on all of the topics. You'll have noticed that each area of study requires you to consider how the operation of the legal system can be assessed by 3 criteria. And those criteria are that first entry on that page, on page 7. Fairness, equality, and justice. Now, you'll have discussed this to some extent, but I just want to take another crack at it today because I think it's very, very important. Unlike the people who are starting Units 1 and 2 this year, who will in fact be working their way through those principles of justice in relation to everything that they're doing, this is new to you, or it was new to you at the beginning of 2018. Now, if this is going to work, well, it'll work, but whether I can work it or not is another matter. Absolutely nothing. Jenny, help. Oh, there we are. Fairness. Just have a look at what's on the board there. This notion of fairness. Fairness requires fair processes. In other words, the system of dispute resolution is the sort of thing that Deborah was talking about, giving you some examples of how the role of the Ombudsman produces fair outcomes, fair processes, in order to resolve more and more disputes. And of course, that's a system that simply didn't exist years ago. And as you've looked at tribunals as well, there are other systems, other processes, which have resulted in the fairer delivery of justice. A fair hearing. It's all very well having a process, but is the hearing itself conducted in a way that is genuinely fair? I have a note somewhere about dictation tests. Once upon a time, when people who'd migrated to Australia may have been looked upon by immigration officials as undesirable, they were able to give them a dictation test. And they could pick any language they liked. And so if you failed the dictation test because it had been given in ancient Swahili, when in fact you came from Sweden, I mentioned a country we talked about before, obviously you're not going to pass, and so you didn't get in. Now, there's no fairness in that. It was deemed fair because anybody could be asked to take the dictation test, but the unfair aspect of it was the process, that the immigration officials, if they deliberately wanted to keep you out of the country, they could quite simply have picked a language that you had absolutely no hope of writing anything down in, and therefore you failed, and therefore you were packed back onto another boat and sent home. Parties should have the opportunity to know the case that's put against them, whether it's a civil proceeding or whether it's a criminal proceeding. You should be aware the person who is the person who is being proceeded against should be given all of the information that is relevant to that, so that they can in fact prepare an adequate defence. They should also be given a chance to prepare their case. I remember a few years ago a student was sent down from the University of Melbourne. That's university speak for thrown out, sacked, for cheating in an exam. Fair enough. But they reckoned that they'd been actually really rather badly treated. They were supposedly to appear before... I'll stand back a bit to stop it from exploding like that. They theoretically were supposed to have appeared before a student, at least a faculty investigation body, to present their case, present their defence. But in fact what they received was a letter saying they'd been permanently excluded from the university. And so this went to a dispute resolution body. The dispute resolution body said that's unfair. They were sent back, and the university faculty had to meet, the body had to meet and hear the defence. They heard the defence, and the person was sacked anyway. But they had been denied the fair process of presenting their defence. They were completely in the wrong. They had no real defence, but they'd been denied the process. And of course, in all cases, we consider that's unfair. If we were to accept that sort of procedure, then we'd be prepared to accept almost anything. Oh, crumbs. We'll get there eventually. Equality. Again, people need to be treated equally before the law. We say in this country that everyone is treated equally before the law. Well, it's an objective, it's an aim. I'm not so sure that it is always carried out. All people need to be given, as I said before, an opportunity to present their case. And that means all people, not just people who are native English speakers or clever people, but all people, regardless of their status in the community. No person should be treated advantageously or disadvantageously. No one should get favoured treatment. We understand that as a principle, and it's something that we aim to carry through. The process should be free of bias, free of prejudice. All people should be treated equally in the process of dispute resolution. The decision makers must be impartial. We've been extremely lucky in this country that our judiciary is wholly independent. Our judiciary, like Deborah Glass, are independent officers. They can only be removed from office by a vote of both houses of the Parliament. The Premier sitting in his office can't say, oh, that judge has been a bit of made some decisions we don't like as a government, sack him. Can't be done. Our judiciary is impartial and independent, and it's very, very important that that should be the case. And finally, there the law is applied equally, and the processes uphold the rule of law being what the law is at any particular point in time. And we'll have a look at access. When we talk about the third principle, remember what I was saying a moment ago, and no doubt you've already encountered these terms, but everything you look at during the course of the remainder of this semester and in semester 4 has to be viewed against these criteria. So if you're looking at the jury system, for example, and Paul Dorr will speak to you later on about that, but the jury system, you need to be able to assess it in terms of the degree to which it contributes to fairness, to equality, and also, here, access. Access to justice systems requires that people do understand their legal rights and pursue their case. This includes more than an ability to access the institutions that hear cases. By that, it means more than just being able to rock up to a court or a tribunal. or the Ombudsman's office. It means, obviously, if you're going to a court, that you are in a position to be properly represented or are capable of representing yourself. If you happen to be impoverished or you don't speak English, it makes it very difficult unless you are provided with appropriate services to rectify those disadvantages that you suffer. It also means being able to approach bodies that provide legal advice, education and assistance so that you can find out what you need to know in order to resolve the dispute in which you find yourself. Receive information about cases, processes and outcomes that Philip was talking about earlier. As victims of crime, for example, being kept up to date with what's happening when the case which involves you as a victim is before the courts or has completed its passage through the courts, even right up to including the period of time or the end of time when a person is being released from prison. What factors, and I've probably touched on many of them, but what additional factors can you suggest which limit those three elements from being delivered in all cases? Can you suggest what factors are at work in, say, our community of Victoria, which limit the extent to which these three criteria or these three elements are in fact delivered in our system? Yeah. Say again? I can't hear you. Yes, language barriers, very important. Clearly, as I said a moment ago, if you don't happen to speak English, going to court is a complete and utter mystery. It's like turning on a foreign language television station and not knowing the language in which the broadcast takes place. You're not going to pick up an awful lot. Yes, cost, of course. Cost, and this has been addressed to some extent by the, pardon me, I don't know who brought this on. That's been addressed to some degree by Victoria Legal Aid and by the advent of tribunals, but it is still an issue, a very substantial issue when it comes to a matter being taken to court. To say that Victoria Legal Aid solves the problem is a misstatement. It goes some way to solving the problem, but it doesn't solve the problem for everybody. What other factors? We've got language, we've got cost, yes? Yes, discrimination on a variety of grounds. Discrimination on the basis of gender, discrimination on the basis of ethnic origin, all sorts of things can have an impact. And we can sit back and say, well, they shouldn't, but it's up to us to ensure, of course, that they don't have an impact, that those sorts of elements are removed from the thinking which governs our justice process. Any others? Any other factors? Yes? Absolutely. Very, very important point. People's education, people knowing that they have a right, as Deborah made the point before, that an awful lot of people don't know that they can bring their problems to the Ombudsman's office. And there are all sorts of, there's a financial services ombudsman, there's a telecommunications industry ombudsman, there's a range of ombudsmen who can in fact aid in the resolution of disputes. But many people simply don't even know they exist. Many people are not aware of the Victorian, the tribunals in Victoria, the range of Victorian tribunals. And that, of course, is a problem. And that means you're going to just sort of sit on the problem that you've got and not get it resolved and be a very, very unhappy person indeed. Later today, sessions will be led by Mr. Paul Daw, the Victorian Juries Commissioner, and Mr. Chris Gill from the Sentencing Advisory Council. And this morning you heard from Justice Philip Cummins, the Chairman of the Victoria Law Reform Commission. Now you should consider, when you go home from here today, think of how those people's organisations contribute to the delivery of fairness, equality and justice. It'd be worth making a note on it. Some of you, I've noticed during the morning, have been making notes. Notes are very important. I'm going to say a little bit more about notes in a minute. But you should consider how the Law Reform Commission, how the Ombudsman's Office, and how the other organisations that you hear about during the day do in fact contribute to equality, fairness and access, how they promote a truly just legal system. It's changed. When I started studying law last century, it's true actually, there were no tribunals, there were courts, that's all. And if you couldn't afford to go to court, too bad. No tribunals, no ombudsman. And of course, a lot of people suffered as a direct result of not being able to have matters resolved, often matters where they were the victims of organisations which had much more money and much more clout than they did. Today, things certainly, thank heavens, are nowhere near as bad as that. Now, what should you be doing now in order to prepare most effectively for school-assessed coursework and for the examination in November? Now, the handout that you've got that I referred to a few moments ago, if you have a look inside the front cover of it, on the right-hand page, I'm talking here about what you should be doing now. What should I be doing now? Now, aside from the obvious things about attending your classes, completing set tasks and making your notes, there are a few steps that can be taken right now which will pay off when it comes to the examination in November. Now, I've given you a copy of the study design. If you want to get the full study design, you can download that. You don't need to go and buy a copy. You can download that from the VCAA website. It would be a very good idea for you to either keep this document that I've given you as the knowledge audit, or get yourselves a copy of the full study design if you want to see what some of the philosophical stuff behind the various sections of it is all about. But the knowledge audit that you've got here really sets out sequentially the bits and pieces of Units 3 and 4. And as you work through Units 3 and 4, you can check to see whether you've adequately noted or adequately covered each of those. The simple reason is that it should be your guide to your revision. You cannot be examined on anything that is not in the study design. On the other side of that, though, you can be examined on anything that is in the study design. So it's really very, very important that you have a copy of the study design or use this knowledge audit and tick off the bits and pieces that you've covered and for which your notes, you believe, are appropriate and adequate. Now, the second dot point might seem a little bit of an odd one. Obtain a copy of the Commonwealth of Australia Constitution Act. Now, again, you can download that. You can go and buy a nice little cardboard-covered copy if you want, but you should have a copy of it. Now, don't panic. You don't have to know it all, but you are going to look at certain sections of the Constitution. You will understand the Constitution much more, or you'll understand the bits that you're looking at much more, if you understand them in the context in which they appear in the Constitution. So when you come to have a look at sections 7 and 24, say on the Houses of Parliament, and you will, or section 128 on referenda, as you will, to understand those bits, you really do need to be able to see where they fit into the whole document. It's not bad reading, the Constitution. Handy to know about it. It's my favourite subject as a law student. Hated property, actually failed property the first time. But I loved the constitutional side of it, and I still do. I'm going to in a moment. Fab, I hadn't forgotten. But seeing I've been reminded, I'll do it now. You'll find also in your kit a document that I wrote earlier in the year. And this actually sets out what you're going to look at when it comes to Unit 4 on the people and the Australian Constitution. You will find it very, very useful when you look at what you have to cover. I've included some cases, some constitutional cases, and I'll say a little bit more about that document in a moment. But Fab reminded me that it's there, and I want you to know that it's there. hang on to that as well, because when it comes to looking at the Constitution in Unit 4, that handout just about covers it. Back to the second page of the original document. Make sure, I mentioned notes before and I said I was going to mention them again, and here it is. Make your topic notes as you go. Make sure that as you complete each topic, you've got a good set of detailed notes on that topic. When it comes to October, you want to be able to reduce your long notes to short notes, just to the key bits and pieces, to help you prep for the exam. If you're making your original long notes in October, probably too late. A good idea to check at the end of each topic that you've got a complete set of notes, and you can use your knowledge audit as a means of ensuring that you have them. It's really important that you do that. Don't specialise, don't leave gaps, don't just pick your favourite bits, but cover all the topics, because the questions on the exam, the 80-mark exam at the end of the year, and it is 80 marks now, can come from any part of the study design. When you're making your notes in relation to cases, the process that I always recommend is to write down 4 things. And they're set out there. I call them the FIDs, the facts, the issues, the decision, and the significance. Now, I'll just explain each one of those. The facts of the case are pretty obvious. And any of the teachers who are here may have heard me talk about this particular case before, and it's on the list of cases that I have there. It's called Grace and Fraser. That's the second dot point on the list there. Grace and Fraser is one of those cases that nobody ever thought legal studies teachers or students would be talking about a few years down the track. Simple case. Lady parks car, forgets to put brake on. Catches the bus and goes into her office in the city, does a day's work. While she's gone, passing vehicles, the vibration of passing vehicles, the car starts to roll. And it rolls into the car in front of it, causing some damage. Now the driver of the car comes back, goes, oops, that shouldn't have happened. But she doesn't do anything about it. She just gets in her car and drives home. What she didn't know was that someone had seen what had happened and had written her number plate on a card and put it under the windscreen wiper of the car that had been damaged. And so a couple of days later, knock, 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 there's a policeman on the door. She's charged with being the driver of a motor car, leaving the scene of an accident without reporting the damage. Gets hauled up before the magistrate's court. Magistrate convicts her. Now, her lawyer, reasonably savvy character, said, no, this is wrong. You weren't the driver of the motor car at the time this happened. You were 5 kilometres away in your office. She said, oh yes, so I was. Let's have a crack at an appeal. Now, what are we going to appeal on? What sort of an appeal is it? It's an appeal on a question of law. What does the legislation mean? The legislation said being the driver of a motor vehicle, leaving the scene of an accident without reporting damage. And so the case went before Mr. Justice King, as it was in those days, in 1982. And Mr. Justice King interpreted the legislation extremely narrowly. He said, no, you weren't the driver of the motor vehicle. Charge dismissed. And she, with a smile on her face, marched out of court. But up there in Spring Street, our parliamentary leaders thought, no, this is not good. This is not what we meant at all. We don't want people getting away with this sort of thing. So what do you reckon they did? They changed the law, exactly. They amended the legislation. Now, how would you amend it in order to ensure that Miss Grace was, in fact, held liable, even on appeal? How would you change it? Yeah. Absolutely right. It was changed to cover the person who was responsible for the motor vehicle being where it was. Now, Miss Grace got away with it, but if you and I did the same thing, we'd be in strife. Now, that's the facts of the case. And we know what the issue was. What did the legislation mean? The legislation had to be interpreted by the Supreme Court, leapfrogs the county on an appeal on a question of law, as you probably already know. So the issue was, what does the legislation actually mean? The Supreme Court determined that it was narrow. The Parliament disagreed with it, changed the law. So the significance of the case, there's several elements of its significance. The first is, of course, that it brought about a change in the law. Sometimes courts, without necessarily thinking they're going to do so, can in fact bring about a change in the law, and this one did. So the significance of this particular case is that it illustrates it's a very good illustration of a number of things. First of all, a hearing in the Magistrates' Court, an appeal on a question of law to the Supreme Court, the relationship between courts and Parliament, and changing the law. So you can use that simple little case that nobody thought was going to be terribly important. You can use that case to illustrate so many different parts of the course. I'll say again what it is. It's a hearing in the Magistrates' Court, criminal hearing in the Magistrates' Court. It's an appeal on a question of law to the Supreme Court. It illustrates the relationship between courts and Parliament, and it can also be seen as an illustration of changing the law. There's no rule that says you can't use the same example more than once. If an example is appropriate, you can use it in the exam or in your school-assessed courseworks as many times as you like, as long as it's relevant to what you're dealing with. So the facts, the issues, the decision, and the significance of cases, that should be how you make your notes. You'll probably look at, 10 cases during the course of the year? Grab a little card and just put facts, issue, decision, significance down the side, and a couple of words beside each one, and look at them from time to time, and that allows you to use your case examples. You'll remember them that way, and you'll be able to use them effectively in the exam. The other element of significance, of course, as I said, is that you can use a case like that in so many different areas. Yeah. How long have I got? I've got 2 minutes, have I? I need another hour. Never mind. Develop notes on your key bits of legislation. Familiarise yourselves with primary source material. Make sure you do that. Obtain copies of past exams and past examiners' reports. Now remember that this is a new study design, so there's a new exam. There's a sample exam on the VCAA website. If you haven't had a look at that yet, have a look at it. Remember, it's an 80-mark exam instead of a rather less high-mark exam. It was 70 marks the last one. It's now 80. So please make sure that you do that. Look and listen, read the newspapers, keep up to date with contemporary stuff. A couple of cases to have a look at on fairness, equality and access. Jago's case, I'll give you a note on it. Have I got it up there? Yes. Jago and the District Court of New South Wales. Some of you will find it in your textbook. Depends which text you're using, but Jago's case is worth having a look at. Jago didn't win, but it was still damned unfair, the whole process. Have a look at the last one. Dietrich and the Queen, 1992. You'll find that in quite a few of your textbooks if you're looking for cases that are clear examples of things that are not fair. The material you've been given should be useful stuff. Don't chuck it away, don't leave it behind. The constitutional material will be a complete mystery to you until you start looking at that in Unit 4, but I can assure you you'll find that that is very, very useful. I've tailored it precisely to the study design, and I've given you examples there, 3 cases which are very, very usable. Good luck in the exam at the end of the year. You are the guinea pigs with the new study design, but I wish you very, very well. Thank you.